Well, good afternoon, everybody, and thank you for joining our YouTube live stream. I'm Brian Horlick, trying to take care of all of your condominium needs. As you know, for those of you that have been regulars, we've started this live stream in March of 2020 when COVID was taking over, I guess, everything. And we wanted to make sure that there was a way that all condominium managers, board members, residents, anybody in fact who was involved in the condominium industry, all the stakeholders had a place where they could come together, ask questions, get answers, get some information, and be able to communicate. And we've continued to do that in spite of COVID not leaving us. And we're going to continue with our live streams every Wednesday at 12 noon, and we hope to continue them even after COVID is successfully defeated. So, as you know, a lot of our chats, a lot of the live stream has dealt with COVID-19, but of course the purpose of the AMA is not only to keep you up to date with the latest developments on COVID-19 as they relate to condominium living, but also to keep you up to date with anything that has to do with condominium and condominium law. So whether we're talking about COVID or anything else, we're available to answer all your questions. We have a number of questions I see, but before we get to the questions, there's just a few things I'd like to touch base on. We have the Condominium Authority Tribunal has come out with some amendments to their jurisdiction. One of the amendments deals with the scope of disputes. So as you know, presently, and since the CAT, or the Condominium Authority Tribunal, has been up and running, it has been dealing solely with disputes related to records. So when owners request from a condominium corporation copies of records or the ability to examine records, and the condo corporation says, well, you know, these records aren't producible, or these records need to be redacted, or for whatever other reason, and the owner disagrees, the owner is able to file a dispute with the CAT, the Condominium Authority Tribunal, and there's a whole online dispute resolution process to get to a result that either both parties will be happy with, or one party will be happy with, or maybe no parties will be happy with. And it's all done at a very nominal rate, nominal cost. And so this is a way to assist unit owners, assist condominium corporations in trying to resolve certain type of disputes in a cost-effective manner. So as of October 1, 2020, the authority of the Condominium Tribunal will expand. As of October 1, 2020, the jurisdiction to hear disputes for the CAT will now include pets. So if you have a pet dispute or a further dispute with any other type of animal, the CAT will now be open for business for pet disputes. Pets or other animals, whether they are in the units or on the common elements, those type of disputes will be going to the Condominium Authority Tribunal. Disputes related to cars, motorcycles, trailers, buses, motor-assisted bicycles, devices used to facilitate the transportation of a person with disabilities, such as a scooter, all of those type of things, disputes related to that will be going to the CAT. Disputes related to prohibitions or restrictions on parking or storing items in a parking area or storage area, whether it's a unitized area, or rather whether it's a unitized area or a common element, those type of disputes will also be going to the CAT. Very, very important to note that if the issue deals, in addition to these topics, but deals with Section 117 of the Condominium Act, which is dangerous activities or dangerous things brought onto a condo corporation's property, Section 117 issues will still be allowed to go to court. So the dispute, if it relates to people, to parking or to the pets, or the storage of the items, if they also have a dangerous activity component, you can still go to court under Section 117. Any dispute that you might have with installation or operation of electric vehicle charging systems are not part of the jurisdiction of a dispute at the CAT, so that's still outside the CAT. So this is what's going on. If there are issues with respect to indemnification or compensation that, for example, chargebacks by a condominium corporation dealing with the pet issues or the automobile issues or the parking and storage issues, those compensation issues will also be part of the dispute at the CAT. So a lot of stuff is moving over to the CAT. As I've said before, the practice of condo law and perhaps the managing of condominium corporations is like being in the Wild West, but it's going to be a wilder Wild West now than it was before, because now not only can condominium corporations file a dispute with respect to these matters against an owner can also file these disputes against a condo corporation at the CAT. And on top of that, to make life even more exciting, an owner can now file an application to the CAT related to these items against another owner. So if I am an owner and I am being abused by the owner who's above me, because that owner still doesn't understand that when you have a pet, you also have a responsibility as a pet owner. And of course, one of the responsibilities is to ensure that when your pet needs to relieve itself, it doesn't do so on the common element balcony above my unit, because it's going to be a problem for me. I don't want to be sitting outside on my balcony with an umbrella and a raincoat. And so if the condominium corporation is not doing anything about this issue, then I, as the unit owner below, can go and file a dispute with the CAT in regards to what I perceive as the situation from the unit above dealing with the pet. So it's not only now condo corporations having disputes with owners, owners having disputes with condo corporations, and when I say owners, I also mean occupants such as tenants, but it's also owners filing disputes against other owners. So things are going to get busy and things are going to be active, and there'll be yet more fun in condominium living. So I will also say, last point here, is that mediation and arbitration on these type of issues, providing, again, they're not within Section 117 of the Condominium Act, dangerous activities, mediation arbitration will not be available. You'd have to go through the process at the CAT. So that's what's going on with the Condominium Authority Tribunal. Last comment on this, if you have a Section 98 agreement and there's a dispute about a Section 98 agreement, which is when the owner makes an addition, alteration, or improvement to a common element, there has to be an agreement under Section 98. If there's a dispute under a Section 98 agreement, that's still not within the jurisdiction of CAT. That's still a Condominium Act issue. So that's what's happening there. Moving on, more exciting news. Short-term rentals, as you know, there's a bylaw that's in place for short-term rentals. That's when you rent your unit for less than 28 days. So those that are in that business, or that's the thing that they're doing, the short-term rental operators have to register with the City of Toronto. As you know, the rolling out of the short-term rental program by the City of Toronto was delayed, obviously, with COVID-19, but it's now moving forward slowly. And so between September the 10th and December 31st of this year, all short-term rental operators will be required to register with the City of Toronto. Note that enforcement is not yet really happening, other than by condominium managers or unit owners calling 311 to complain. But again, as we move forward, either post-COVID, with or without vaccines, the city will start to become more active in ensuring that those people who have thought and have for a number of years now decided that the best way to make money and do no work is to turn a residential condo into a ghost hotel, those people are going to have, they're going to be disturbed in their business model when the city starts coming out and investigating. So keep in touch. We'll continue and monitoring that situation. We continue to get up-to-date emails from the city, and we'll make sure that that the live stream here will address those issues, and you'll be the first to know. All right. Other important issues. As you know, the emergency order that was in the province of Ontario was rescinded. As you know, that was in July 24th. The amendments that were specific to the emergency orders and that amended the Condominium Act will be over on November 21st. Specifically, AGMs will now have to take place because the suspension on the 6-month time period is effectively over, and the emergency order said when that emergency order is revoked, condo corporations will have basically 90 days to 120 days to have their AGMs if their AGMs fell within the period of the emergency order. And that's why many AGMs now have a deadline of October 22nd and November 21st. Very, very important. I cannot stress enough that the bylaw, the suspension of the requirement for a bylaw to have a virtual meeting or electronic voting, that suspension of a bylaw will be over on November 21st. You really need to have a bylaw drafted for your condominium corporation. The bylaw needs to be passed on or before November 21st, because after that, you will not be able to have an electronic voting or a virtual meeting without the bylaw. So best to do it now when you can still have a meeting and call a meeting virtually. Very, very important. I will also tell you, as has been set out before, mentioned on this live stream, that as I sat and heard all of my condominium corporations and all of the managers complain that they couldn't get appropriate dates to hold their AGMs and other owner meetings, such as bylaw meetings, because the 2 or 3 suppliers of virtual meetings and electronic voting were too busy and couldn't handle all of the demand. I sat there and said, what can we possibly do to assist the condominium corporations and the managers? And through a lot of diligence and hard work by members of my team, our office, as I have said, has now been able to source a state-of-the-art electronic voting platform. We are now hosting and chairing virtual AGMs and virtual owners meetings with electronic voting. So we've got a beautiful package. I'm encouraging the managers to call us. The pricing is what I call sensible, and we refuse to gouge the condominium community because there are only a few suppliers offering this. So the prices are sensible, the package is wonderful, the security features are state-of-the-art, where we have confidentiality of all proxies that come in electronically, or votes that come in electronically. Everything is done by codes and nobody knows who's voting for what. So it's a great system. Now, we're going to go to some questions. We've got a bunch of them, and then we'll discuss some cases if we have time. My intention is, as we move forward with our live stream, my intention is that we are going to start spending some more time on various types of cases. For example, we may have one of our lawyers who is an expert in insurance law, David Lella, insurance law and construction deficiencies. We may have him come on and spend a substantial amount of time dealing with carry-on warranties, construction deficiencies, and that type of thing. We may have some of our litigators come on and deal with various topics such as, defamation, noise issues, various parts of the Condominium Act that come up all the time, flooding, that type of thing. So let's go to the questions. Jerry DiDonato. Good day, Brian. I understand that the song Baker Street by Jerry Rafferty is one of the most famous songs for sax players. Are you up for a demo? Oh, Jerry, you're killing me, man, because Jerry DiDonato is the culprit who, after after it came out that I did play a saxophone, he was the culprit that pinned me down on a date and made me actually play it, which is actually recorded you can see it on the YouTube channel. We recorded a little saxophone thing a few weeks ago. So that was Jerry. And of course, we can't forget the biggest troublemaker, Murray Johnson, who put it out there initially that I played the sax. So I don't know, Jerry, that is one heck of a good solo played by somebody else. I'll have to see if I'm up to the task. We'll decide. Question. Our vacant land condo corp has been confronted by what the board perceives is a very complex legal issue that will require your expertise. We would like to invite you to meet with the board to present and explain the circumstances underlying the issue. What is the procedure for inviting you to this meeting? So, Jerry, let me just say this. Our meetings today are done by Zoom. They're done remotely. We are able to meet and talk to and speak with all of our clients on a remote basis, and we'll use any of the available software out there that's comfortable for the board, and we can set something up with you, with the board members, in fact with anybody who wants to talk to me. I'm pretty lonely these days. I sit in my office from the morning to the night doing condo law, so anybody who wants to call me and say hello, they can. But yeah, that's what we do. As far as AGMs, I think we only had so far of really the hundreds and hundreds and hundreds of AGMs that we are chairing, because we have a whole group here of 6 lawyers that are out all the time chairing meetings as necessary. But there's only been one client who has really been insisting on having an in-person meeting. Most clients are understanding that managers might not feel safe going to an in-person meeting, that lawyers, auditors might not feel safe, that your own residents might not feel safe going to in-person meetings. And so, that's something that we do. We're doing it virtually. I will discuss after we finish going through some of the questions what you really need if you are a condo corporation that is insisting on having an in-person meeting or a hybrid meeting, an in-person/virtual meeting. You need to really think this out. You need to really take into account social distancing and keeping everybody safe. But we'll get there shortly. All right, Bruna H. Resident claims compensation for cleaning of rust stains on the car after the drain pipe in the garage leaked. He had a full gold detailing package. Should the corporation reimburse him? If yes, should it be in full? So I'm going to say this, that if the corporation or if a common element caused damage to somebody's property, I think that it would be appropriate, not knowing all of the facts, of course, but I think it would be appropriate to have the gold detailing package. Well, I wouldn't say reimburse for the whole package, because the gold detailing, I'm sure, came with a lot of other stuff, but to definitely have the rust stains removed. Okay, I wouldn't go through the whole detailing package inside the car, outside the car, but I would consider in a serious manner paying for whatever the cost, the reasonable cost, to get the rust stains off the car. Next question. Dorothy Wolfson. Can the board give money to a condo committee established by the board for the committee to use at its discretion? The committee has been established to dispute a proposed high-rise. So what I'm understanding from this question is a committee has been established to take certain actions on behalf of the condominium corporation. I'm going to suggest that if what the committee is doing is pursuant to the direction of the board, and the work of the committee is pursuant to the objects of the condominium corporation, I would suggest that based on appropriate receipts, it's appropriate for the condo corporation to pay those receipts. Depends what they're doing, but if there is a cost involved, I would suggest that it would be appropriate, keeping in mind you're using the common expense money, the operating fund, which can only be used for certain defined objects. So if you look at the schedule to the back of your declaration dealing with the uses of the common expenses, I'm sure you could read that in there and it would be okay. Again, it has to be with appropriate receipts. Oh, and Dorothy continues, the proposed high-rise is significantly denser than presently allowed in Toronto. So definitely, you have this big building or this developer who wants to put this monstrosity next door to you, and certainly, it has been shown in the past that if the corporation gets involved early in the stage of the planning process and becomes a thorn in the side of the declarant / the developer, there's a very good possibility that working together, the developer may somehow change the plans somewhat so that the building gets more sun, more shade, maybe has less windows facing your building. There's things that can be done. You just have to get yourself into the game. Property manager. What are the obligations of corporations while terminating janitorial and super contracts? Anything related to Bill 7. So Bill 7 is a piece of legislation that rightly or wrongly covers certain employees that are at the condo corporation, and there's provision in the legislation whereby condo corporations, when they're changing contractors, the contractors have to take over the existing staff, or the staff has to move on with the former contractor to another location. So I think it's important, if you're going to be terminating those type of employees, that you seek send off an email to your condo corporation lawyer, and based on the type of employees that you have there, they can tell you, and I can tell you exactly what you should be doing regarding to the legislation. But one of the things, of course, you need to do is you need to call before you change people, because once you terminate them, the ball starts rolling with all sorts of issues such as wrongful dismissal and payment in lieu of termination, etc. So very important that. And that's also with security contracts as well. Olivia Clavo. Hi, Brian. Happy Wednesday. I am waiting for your response for our upcoming electronic AGM end of October. As far as I know, you have confirmed our end for the date and time. Well, okay, Olivia, I'm happy to be of service to you. And when I finish the live stream, I'm going to go upstairs and I'm going to check, but I'm sure everything is fine and good. And we'll be happy to assist you and your community. Olivia is managing a vacant land condo corp in Ballantrae. And if you haven't been up there, it's a beautiful community. It's made up, I think, of about 7 or 8 vacant land condo corps surrounded by a golf course with water and a recreation center. When you go up there, you think you're in a beautiful place, and that they have these beautiful places, these golf communities, for example, in Florida. It's just a wonderful place up there. So keep on doing a good job. Julia Lurier. Hi, Brian. Thanks for an informative show. So for those of you who don't know, Julia is one of our condominium lawyers, and I'm apt to say that we miss her dearly because she's on maternity leave. She'll be back in, I think, the 1st of November. And what I have in my office is a calendar, and every day that goes by, I mark it with an X, and it's one day closer to when Julia is going to return. I will tell you, and I'm not kidding, she is a tremendously great and fantastic condo lawyer. She knows her stuff, and what she is above anything else is passionate about what she does, and it shows and it shows in the work that she does. So Julia, spend as much time as you can with your kids now, because you're not going home starting November the 1st. I have lots of files for you. Harlan Stavis, Jerry, why are you requesting only one song from Brian? I'm sure that Brian is very capable of playing a whole set of at least 6 songs. Brian, please set a date for your sax set. Well, okay, to Jerry and to Harlan, in the days before COVID, you know, it was funny because here I am, a serious condo lawyer, and I play in this 2 bands. One is a swing band. They play swing music, and there's about 25 people in there. And one is like this sax jazz ensemble. There's about 7 people in that. And one of my great days is when we booked a gig, and we played at Grossman's Tavern on Spadina. Can you imagine Brian Horlick, the condo lawyer, playing in his saxophone in a tavern? So I'll tell you this, guys, once COVID is done and we get a gig at Grossman's Tavern, I'm inviting everybody who listens to the live stream, and you can quote me on this, everybody's going to get a beer on the house. Well, on my house, okay? On my tab, you're getting a beer if you come out. All right, next. Bruna H. Can the corporation issue tickets to residents who park continuously in visitor parking or in the driveway? If yes, can these tickets be challenged in court? Are they collected the same as common expenses? So the issue of tickets is dependent upon where the car is. Is the car in a unitized spot, i.e. is the person parking in somebody else's spot, or is the person parking in the common elements? If the person is parking in the common elements, you need to do one of 2 things. You need to either have a service, a towing a company to come and give the ticket, or you need to file certain documentations whereby your concierge can then be the quote-unquote agent for Toronto Police Services to write up the tickets. So you can ticket, but you need to. It's done through the I think City of Toronto and Toronto Police Services, and you become an agent of the police in order to do the ticket. But you can do it. You can definitely ticket, and you can ticket and tow. And can a ticket be challenged in court? Well, any ticket can be challenged in court. I don't know what the owner is going to say, or the resident. Well, that car that's there with my license plate's not my car. I guess that's his argument, but I don't know how far that's going to get. So absolutely, you need to enforce these things, because you're talking about visitor parking. There are legitimate visitors who would like to park. There are people that have handicap needs that would like to park. If they're parking in the driveway, you have the potential for a fire in a corporation where the fire trucks would have to come into the driveway. So this is something that needs to be attended to. All right, so we have more questions on the top. Okay, so those are the questions. We'll wait for some more questions. So I said before, in-person meetings. For those of you that are thinking of in-person meetings, you need to understand, of course, that at the present time, there are requirements. And number 1, you cannot have a social setting, a social gathering for greater than 50 people. So what does that mean? That means if the board intends to go to the meeting, let's say there's 5 people there. So from your 50 people social setting, you're down to 45. If your manager and an admin go, that's another 2, so you're down to 43. If your lawyer goes and your auditor, you're down to 41. So let's talk about numbers. The most people that will be able to attend in person is 40. You need to have social distancing. You need to ensure that you've got 6 feet apart between all the chairs. You need to ensure that when people come to register, they're not standing in a line up close to each other. So sort of like you're going into the big box store, every 6 feet the lineup goes. Every 6 feet is a person waiting to go into the store. That's what you're going to have for registration at the AGM. You're going to have to ensure that the staff doing registrations is safe. You're going to have to likely have a plexiglass between the person who's doing the registration and the person that's coming in to register, the unit owner who's coming in to register, because that's what you need. You're going to have to wear masks because You're going to be inside, and if it's in your condominium common elements, obviously you have to wear your mask. People will be masked throughout the whole thing. Difficult to be heard when you're wearing your mask. Although, like a gym, they say when you're involved in vigorous physical activity in the gym, you can take off the mask. And I'm going to say that an AGM certainly is similar to having vigorous physical activity. At least for me it is. And so maybe you'll be able to slip off your mask when you're making a speech. You wouldn't be able to use a mic because that could lead to the spread of COVID-19. You're going to have sanitization of the room before you go in there. Again, people should not be walking around the room, shaking hands and talking. They should get up only to use the washroom. They should bring their own pens. There's an issue of touching paper, which is the ballots, and how will you work that out, and collecting the ballots. I find that when we're talking about an in-person meeting and you're talking about contested elections, you're also talking about scrutinization of the ballots. You have scrutineers appointed. So how will that work? You have a number of people hovering over the ballots to make sure that things are being done accurately. Very, very difficult. So you have to really think it through if you're going to be wanting to have an in-person meeting or a hybrid. I'm still of the view, strongly, that today we should continue to have virtual meetings. The virtual meetings should be either electronic voting and paper proxies. That to me is effective. If you have a community where technology is problematic, so you have a community where people would not be able to vote electronically because they're not good with the computers, then for a community like that, you may say, okay, electronic voting is not going to work. What we're going to have is paper proxy, and you can have voting by paper proxy. I suggest that, if you're going to, have the meeting, it's going to be electronic voting and paper proxy, or just paper proxy, and it should be really not in person unless it's absolutely necessary, and I can't see why it would be. I think the virtual meeting is really the way to go. You look at the news, COVID-19, everybody's doing their part trying to stop the spread of that pandemic. Everybody's wearing masks. People are being careful, but I don't think it's going to take much for something like that to rear its ugly head if people become loose with respect to the rules. And so what would be the benefit to have an AGM, to have it in person? God forbid somebody had COVID and came to the meeting. They were asymptomatic. They didn't know they have it. And all of a sudden, this pandemic has now become prevalent in your corporation. So for those of you that, think of the bottom line and the dollars, it would be a problem. It would be, it would be a financial problem. You'd have to have more people at your building cleaning. The word would get out that your building has a pandemic. Oh, it would be just terrible from every which way possible. So you really have to consider what you want to do there. All right. All right, that was it. So okay, that's my comments on the in-person meetings. I'm going to say that we have a few interesting condominium cases that have come out, which I'm going to discuss. So, Condominium Authority Tribunal, prior to October 1, the CAT has been dealing only with disputes for records. After October 1st, as I said, the jurisdiction will expand greatly to pets and to parking and to lockers and all sorts of good stuff. So going to some CAT decision now, the CAT was really set up to be on an online dispute resolution, quick and easy dispute resolution matter. It's not going to cost owners or the corporation a lot of money. and so, it would just get issues that were problematic resolved. There's a provision in the Condominium Act which allows the CAT to levy or to charge a penalty, in a CAT decision. And I will tell you that there's a recent case. It's Brown versus Peel Condo Corp 21. And in that situation, a unit owner asked for a number of records. The records were really simple things like, minutes and financial statements and contracts, things that nobody would think you shouldn't give, budgets, list of units that were rented in the building, etc., maintenance contracts, simple stuff. But this condo corporation refused to give over any of the records, and the owner, who was really at the end of her rope, filed an application with the CAT, and the condo corp hardly participated in the proceedings. At the end of the day, of course, the condo corporation was ordered by the CAT to release the books and records which were asked for properly by the unit owner. Interesting, there was a penalty that was levied against the condominium corporation for the non-production of the records. The penalty was $4,000 plus the costs incurred by the unit owner to bring the process forward, which was $200. I will tell you this, a similar case such as this, in the beginning when the authorities first started rolling out cases in 2017, they would have ordered a penalty at that time for probably around $2,000. So it's interesting that the Condominium Authority Tribunal seems to have given everybody a chance to get with it, to get with the program, and to start, providing books and records for examination or inspection or copying that were appropriate. But it seems that the penalties now are going up, now that everyone has had a chance to see what the CAT is all about. So this is a penalty for $4,000. There's another interesting case, PCC 223 versus Tung, and that was a case of a industrial unit condominium corporation. The unit owner was did damage to her HVAC unit on her roof, which of course she said she didn't. The corporation said she did. They charged her back money because of the damage to the roof. She refused to pay. The condo registered a lien. She still refused to pay, so the matter went forward with a notice of sale and an application for possession of the unit so that the corporation could sell it. And the owner in court brought up a defense that she never actually caused those damages, and it was improper to move forward with such a case, and the lien was improper. And the judge hearing the case said, okay, he was going to put it over for a trial to make a determination on whether in fact the damages had occurred. So the moral of the story is, just because there's damage, it doesn't mean that it's automatically the owner's responsibility. And just because a lien is filed and the process moves forward, it doesn't mean that the owner cannot make representations in court to have a judge order that the damages, if any, be proven. So that's important as well. Another case here that we have, which is an interesting case, deals with noise. And so there was a case here where there was a lot of noise, and the question became, what is the responsibility of the condominium corporation when the corporation is faced with a noise issue, which many corporations are? So the number one thing is you cannot, as a manager, ignore the situation. You need to take steps to investigate the situation. And once you take the steps to investigate the situation, if required, you would have to have a sound test. The courts have frowned on taking a position that if the sound test comes back and the sound test shows that the sound is within a reasonable parameter, the courts have frowned on taking the position that if the sound test shows reasonable noise, then the unit owner who's making the complaints should pay for the sound test. The judges don't like that, and the judges are of the view that the cost for the sound test should be that of the condo corporation. So the question is, what do you do for noise? Well, number one, you verify the complaints. Very important. You need to take them seriously. As a manager or as a board, you need to send out enforcement letters to the person making the excessive noise. Again, if necessary, to conduct noise testing. If needed, you have to engage in perhaps mediation to move this thing forward, but you cannot just ignore it, and you need to move forward. I'm going to suggest with mediation and arbitration to ensure that the matter is properly dealt with, because otherwise a unit owner would be well within his or her rights to bring an application against the condo corporation for oppression to say that they were suffering from noise and their rights were not properly taken into account by the condo corporation. Next, we have the issue here of access. So as we all know, under the Condominium Act, there is a right of entry to the corporation to go into a suite with respect to the duties and objects of the condominium corporation. So that's very important, and every so often you try to enter a suite and the unit owner says, no, I'm sorry, you cannot come in. And as a manager or as a board member, you say, but we're in the process of doing whatever work, whether it's the piping or checking for the fire code issues, and the owner says, I'm sorry, that's your problem, can't come in. And so what do? Well, if you need access, at the very worst case, you'd have to make an application to the court, and in appropriate circumstances, the court would grant access, whether it is for maintenance and repairs or whatever. In this case, that was TSCC, Toronto Condo Corp 1724 versus Evdasin. In that situation, it was one of those situations where there was high-tech piping throughout the entire building. The condo corporation did a bulk high-tech piping replacement, which means that the contractor had to go into everybody's unit and unit by unit change the piping within each person's unit from high-tech to an appropriate type of piping. One of the unit's owners, of course, said, no, you can't come into my unit. And that unit owner not only refused to allow the condominium contractor to go into the unit, but also refused to himself or herself attend to getting their own plumber certified to properly change the piping. So corporation was left with an entire building with piping that had been changed except for one unit. The corporation went to court. The judge was very clear in that the condominium corporation had a right of entry, ordered the owner to allow the condo corporation to go in, ordered the unit owner to allow the piping to be changed, all at significant cost to the unit owner. So that's what happened there. Water penetration and condos go like a hand in a glove, especially if you're in a high-rise. You can always expect that one day the floods will come. And when they come big time. So as condominium managers, as board members, you have to know what you're dealing with and what to do. So number one, there's do's and don'ts, and I will discuss with you what you should and shouldn't do as far as water penetration. I gleaned this out from the case. You should take a water penetration complaint seriously. So if water's coming either from a flood or water's coming from, if you're in a townhouse, it's coming from the outside and the whole basement is getting flooded, or the living room, or water's coming in through the roof, you need to take this seriously. You need to have the matter investigated promptly. You need to come to the source of the water penetration. You need to get an engineer's report. You need to hire contractors to remediate the situation. And even if litigation is pending, you still need to move forward to remediate the problem. What you should not do is deny responsibility, that it's on the first instance, that it has nothing to do with the condo, and that it's the owner's responsibility, and that the corporation needs evidence that to establish that it has responsibility in this situation. No, you need to act quickly, you need to act positively, and you need to ensure that the matter is properly investigated. Again, as I said before, the cost of the investigation to be borne by the condo corporation, and then move forward with the repairs, provided, of course, it is condo corporation's responsibility. But you can't just take the tired excuse of, oh no, this is not a condo corporation issue, this is your own issue, you deal with it. That is the attitude that comes up in the decided cases, and it's never a winning attitude. All right, we have a few more questions. Olivia Clavo, can we have the paper proxy deadline a day before the meeting, or the deadline has to be on the day of the AGM meeting to reduce potential chaos when people gather at the registration desk? Well, Olivia, that's a very good question. So I'm going to say this. I am always in favor of a proxy submission deadline. I've always been in favor of that before COVID. Whenever you've got let's call it a candidacy that, people are all vying for the candidacy, and it's a disputed, candidacy, we have different groups running. What I don't want to see as a chairperson is, if registration is from 6:30 to 7, I do not want to see 150 proxies submitted at 1 minute to 7, and on those proxies it says that they're dated the date of the meeting and they're dated at 6:59. I don't want to see that, because the chairperson and the registration table have absolutely no time to review the proxies, to ensure their validity, and to have the meeting start on time. So I don't want to have move forward with a meeting where I'm not confident in the voting. I don't want to move forward where we haven't been able to properly check the proxies. I don't want to move forward where proxies come in and either we do a good job checking the proxies and the meeting starts at 11 o'clock at night, or we move forward with proxies that we haven't been able to properly look at. So yes, I feel this is appropriate. I feel not only is this appropriate for pre-COVID era, but even more appropriate with COVID, because you cannot have all sorts of people registering documents if you're doing an in-person meeting and coming in with proxies and registering at the same time. You're really doing harm to your community. So Catherine Barbolini says, you guys are great. Well, let me tell you this, Catherine Barbolini, you're great. And I'm going to tell you, this is not the Catherine Barbolini show, but I will tell you, Catherine is a manager, and she is so well read. I often say about her that she should have been a condo lawyer and not a condo manager. And if she was a condo lawyer, she'd be the person in law school who always got the A's that everybody hated. There you go, Catherine. Catherine Barbolini, we have a problem with dogs. Oh, by the way, they would hate you because you were so smart. We have a problem with dogs doing their business at the main entrance. Can we use the recorded video surveillance footage in order to determine the offending party and send out an enforcement letter? So this sounds to me not like rule enforcement, but this sounds to me like an issue dealing with the deterioration of the common elements due to the dog urine. And therefore, it's a Condominium Act issue. It's a dangerous activity that was going to bring all sorts of issues, including the issue for bacteria into play. And so I would say yes for such a thing. You can look at your cameras and you can see which are not the negligent pets, but the negligent owners who refuse to properly take care of their pets. Rudy Petershofer. Rudy, how are you? And as I said last time I did the live stream, and I'm going to say it again, Rudy is probably one of the first people in management that I know of that has brought to the forefront the issue of ventilation with respect to COVID-19 and how improper ventilation can assist in the spread of that virus. And Rudy was good enough to send me a very excellent report, an ASHRAE report, which I spoke about in the live stream 2 weeks ago. So Rudy, thanks a lot for your contributions and really for assisting the condominium community in an area where people, before you brought it up, I don't think people were really thinking about the ventilation issue. And the more I've been reading about it, the more important I see that it is. So, if you've got stuff like Rudy had, and you think that's something that is relevant for the condominium community, I'm going to urge you to email it to me, and I will absolutely bring it up on the live stream. And this will be further information, and it will be of assistance to everybody, because at the end of the day, we're all on the live stream together so that we can all work together and acquire knowledge together. So the question is regarding committees: is it necessary to have a provision in the corporation's bylaw that also authorizes the use of committees? Well, I'm going to suggest that, in some of the bylaws you're going to have, there'll be provisions. They'll talk about committees. Probably in a lot of condo corporations, the bylaws will be silent. I think it would be appropriate to set up a policy, unless I think this policy would be far better than, an amendment to the condo documents, and a policy setting out the governance of that type of thing. The more people that are involved for the right reasons in condo, the better. And you do want your community involved. All you have to do is read about or listen to things that have happened in the past in condominium communities where nobody cared, where nobody was involved, and the result of nobody caring and nobody being involved is never a good one. So get involved, committees or on the board, but get involved. Dorothy Wolfson, our condo does have a provision to authorize committees, so excellent. So that would probably be a provision in your bylaw. Sherry Govro, what about access to townhouses? So I'm not quite sure. That must be related to one of the past questions, but I'm not quite sure. Oh, access would be the right of entry. Yeah, so right of entry under the Condo Act is a right of entry to the unit, whether it's a townhouse or it's a high-rise. It's the same thing. You're going into somebody's unit, and you have, as a manager, as a agent on behalf of a condo corporation, fulfilling the objects of the condo corporation, 100% the right to enter. If it's going to be an issue, I would suggest you don't go yourself. I would suggest you go with either a security guard or a board member, but not yourself. Question, Jerry DiDonato. Can a board ask for reasons as to why a director who previously served on the board and subsequently resigned, not for medical reasons, before their AGM term expired and now wishes to run again? Look, can the board ask reasons? Sure, they can ask reasons, and owners can ask reasons as well. Sometimes at the AGMs, there's a Q&A for the candidates. Sometimes there is, and sometimes there isn't. But if somebody had a burning question, like, we have a AGM, we have candidates up there, and if I'm sitting there as an owner and I may want to know, are you, for example, a short-term rental operator and you're running for the board of our condo? I think that's a fair question. Or are you a contractor that has a relationship with our condominium community? There are questions that need to be asked, and I don't see why it would be inappropriate to ask those questions. I don't think there's a obligation on the person in this situation who's running for the board to say why they resigned. They could have had many various reasons. So I'm going to just say that getting back to the issue of voting and proxies and meetings, I'm just going to briefly tell you a quick story about a meeting that I was involved with on this last week, one about a week ago. It was a hotly contested meeting with two groups battling it out. The voting was done by paper proxy only. We did the meeting virtually, so the meeting was broadcast virtually. And when it came down to the voting, of course, the voting was all by way of proxy. What happened in that specific case is that because the list of owners of owner-occupied units was in a deplorable condition, we were not able to rely on that list. And because we couldn't rely on the list of owners of owner-occupied units, we couldn't move forward with that election. And because we couldn't move forward with that election, it meant we couldn't move forward with the election for the general positions. Now, I chaired the meeting, and I take my meetings very, very seriously. And there's a substantial ramification on meetings and the results of meetings. And you always want, as a chairperson, you are obligated to make the best and the right decisions, and there's legal obligation on you to do so. And so, because of the deplorable situation on the records, as a chairperson, I felt that I could not certify the results of any election because of the problems. We went through the entire agenda of the meeting. I adjourned the voting aspects so that our office, and I had appointed two scrutineers from our office, two lawyers from our office to be scrutineers, and I had them, get the proper lists, review the proper lists, meticulously go through all of the information, and that took up 3 or 4 days to do. I have to tell you, it was a very large condo. We finally got, as best as possible, all of the information, and then I wrote a chairman's decision, which was then distributed to all of the unit owners, and that decision set out the results of the election. So that whole process took about a week. So I'm going to tell you this, the moral of the story for managers and for boards, I know that paperwork is just paperwork, and there's so much paperwork, but that stuff really makes a difference. It needs to be perfect. So whether it's an owner's list an owner's list with off-site addresses, on-site addresses, it has to be as perfect as you can get it. Whether it's incident reports from security, it has to be as perfect as you can get it, because all of the documentation that is produced in the management office is hugely important. And so I'm going to finish today by saying this. You need to pay a proper fee to your management company. If you do not pay a proper fee to your management company, they cannot hire a proper manager for your corporation. They cannot train those people, they cannot keep those people, and the whole thing becomes a mess. So, ladies and gentlemen, it all starts from, to me, in any view, it starts with the boards, and starts with the boards understanding that your condominium community, your condominium units are the biggest investments that you're going to have. It's exceptionally important that your community runs properly. It will never run properly if you refuse to pay your management company a proper fee and you refuse to allow them to provide a manager who can do the job, because you can't attract talent if you don't pay them, and you can't train them if you have no resources, and you can't have resources if you have no money. So, ladies and gentlemen, my parting words for this week's live stream is make sure your management company is getting a proper compensation, and make sure your manager is being paid properly, as well as your admin. And a happy management company, a happy board, and a happy community, that's what you want. Ladies and gentlemen, I want to thank you for your time in coming to see our live stream. We'll have Bradley Chaplick here next week imparting more great information to you. Our job is to make you become condo geniuses. Ladies and gentlemen, thank you so much. Have a great rest of the week.